A section-by-section walkthrough of California Form FL-105 GC-120, the UCCJEA declaration required whenever a family law case involves minor children, including residence history, other custody cases, and common mistakes to avoid. What is Form FL-105 GC-120? Form FL-105 is the California Judicial Council form titled Declaration under Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA. It carries a second number, GC-120, because the same form is used in guardianship cases handled in probate court as well as family law cases. The UCCJEA is the law that determines which states' courts have authority to make and enforce custody orders when a family's history touches more than one state. Before a California court can rule on custody, it generally needs to confirm California is the child's home state, meaning the child has lived here for a set period immediately before the case was filed. FL-105 is how the court gathers the facts to make that determination. Why the court needs this beyond FL-100, the petition or response already tells the court that minor children exist and where they currently live. What it doesn't do is establish a history. The UCCJEA looks at a pattern of residence over time, not just a current address, because custody jurisdiction can otherwise be contested between two states if a family has moved recently. FL-105 supplies that pattern so the court can confirm at the outset that it is the right court to decide custody, rather than risking a jurisdictional dispute later in the case. When you're required to file FL-105, FL-105 is required anytime a family law case, most commonly a dissolution, legal separation, nullity, or standalone custody case, involves minor children. It is filed together with your petition or response, whichever one you are filing. If your case does not involve any minor children, you do not need to file FL-105 at all. For background on the form that most often triggers this requirement, see how to fill out Form FL-100. FL-105 and GC-120 are the same form under two different numbers. Family law cases, dissolution, legal separation, nullity, and standalone custody actions use the FL-105 number, while guardianship cases filed in probate court use GC-120. Section-by-section walkthrough of FL-105, here's what the form actually asks you to provide. Case information. At the top, you'll enter the county, the names of the parties, and the case number once it's assigned, the same way you would on any other form in your case. Child information. For each minor child involved in the case, list the child's full name, the child's date of birth. If there is more than one child, you'll list each one separately. Most versions of the form provide room for several children and an attachment page if you have more. Residence history. This is the core of the form. For each child, you'll provide their residence history, commonly covering the last 5 years, or since birth if the child is younger than 5. For each address, you'll list the address where the child lived, the approximate dates the child lived there, the name of the person or people the child lived with, a parent, both parents, a relative, or someone else. If a child has lived in more than one state during that period, list every address in every state. This history is exactly what the court uses to apply the UCCJEA and confirm which state has jurisdiction. Other custody proceedings. Next, you'll disclose whether you know of any other court case, past or pending, in California or any other state, involving custody or visitation of the same children. If one exists, you'll identify the court, the case number if known, and the nature of the case. Disclosing another custody case is not optional. If two courts are unaware of each other's involvement with the same children, it can lead to conflicting custody orders and serious complications for everyone involved. Other people claiming custody or visitation. Finally, the form asks you to identify anyone else, beyond the parties to your case, who currently has physical custody of the children or who claims custody or visitation rights to them. This might be a grandparent, another relative, or a guardian. If no one else fits this description, you'll indicate that as well. Signature under penalty of perjury. Like most judicial council declarations, FL-105 is signed under penalty of perjury, meaning you're certifying that everything you've written is true and correct to the best of your knowledge. Take the same care with this form that you would with the petition or response itself. Common mistakes to avoid: leaving the address history incomplete, especially when a child has moved between counties or states; forgetting to file FL-105 at all when the case involves minor children; not disclosing another pending or prior custody case involving the same children; guessing at dates instead of confirming them, since the residence history is what establishes jurisdiction; leaving out a relative or other adult who has actual physical custody of a child, even informally. What happens after you file FL-105? FL-105 is filed alongside your petition or response and becomes part of the court file. It is generally confidential and not served on the other party in the same way as the petition itself, since it can contain sensitive location information, though your county's Superior Court Self-Help Center can confirm local handling. Once filed, the court uses the residence history you provided to confirm it has jurisdiction before making any custody orders. If the history shows the children have significant connections to another state, or if another custody case is already pending elsewhere, the court may need to resolve that jurisdictional question before it can proceed. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-105 for you. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.